الجامعة الإفتراضية السورية. كتاب القانون الدولي للدكتور عماد الدين محمد. تقدمت مبادرة ضوء بصوت حمام. Module 4 International Humanitarian Law. Module Objectives. By the end of this chapter, you should be able to define the meaning of humanitarian law. Recognize the two branches of international humanitarian law. Trace the historical origins of international humanitarian law and the ancient position of international humanitarian law before it was codified. Understand the two principles of military necessity and humanity and how they affect international humanitarian law. Identify the essential rules which govern international humanitarian law. Explain the difference between jus ad bellum and jus in bello. Be able to determine under what circumstances international humanitarian law should apply. Distinguish between international armed conflict, IAC, and non-international armed conflict, NIAC. Understand the Geneva Conventions and their additional protocols. Distinguish between international humanitarian law and human rights law. Understand the concept of use of force and the conditions of detention. Terminology. The term international humanitarian law, law of armed conflict, and law of war may be regarded as all being similar to each other in meaning. However, the ICRC, international organizations, universities, and states tend to prefer to use the one term, international humanitarian law, or humanitarian law, which can apply to all the other terms which may be used. Geneva and The Hague. IHL has two branches. The Law of Geneva. The Law of Geneva, which is the body of rules that protects victims of armed conflict, such as military personnel who are hors de combat and civilians who are not or are no longer directly participating in hostilities. The Law of The Hague, which is the body of rules establishing the rights and obligations of the belligerents in the conduct of hostilities, and which limits means and methods of warfare. These two branches of IHL have derived their names from the cities where they were initially codified. With the adoption of the Protocols of 8 June 1977, additional to the Geneva Conventions, which combine both branches, this distinction has become a matter of historical and scholarly interest. Military necessity and humanity. IHL is a compromise between two underlying principles, of humanity and of military necessity. These two principles shape all its rules. The principle of military necessity permits only that degree and kind of force required to achieve the legitimate purpose of a conflict, i.e., the complete or partial submission of the enemy at the earliest possible moment with the minimum expenditure of life and resources. It does not, however, permit the taking of measures that would otherwise be prohibited under IHL. The principle of humanity forbids the infliction of all suffering, injury, or destruction not necessary for achieving the legitimate purpose of a conflict. Jean-Jacques Rousseau 1762, said, "War is no way a relationship of man with man, but a relationship between states, in which individuals are enemies only by accident, not as men, nor even as citizens, but as soldiers. Since the object of war is to destroy the enemy state, it is legitimate to kill the latter's defenders as long as they are carrying arms. But as soon as they lay them down and surrender, they cease to be enemies or agents of the enemy, and again become mere men, and it is no longer legitimate to take their lives." Essential IHL rules. The parties to a conflict must at all times distinguish between civilians and combatants in order to spare the civilian population and civilian property. The civilian population as a whole and including individual civilians may not be attacked. Attacks may be made only against military objectives. Parties to a conflict do not have an unrestricted right to choose methods or means of warfare. It is forbidden to use weapons or methods of warfare that are indiscriminate, including weapons or methods of warfare that are likely to cause superfluous injury or unnecessary suffering. It is forbidden to wound or kill an enemy who is surrounding or who can no longer take part in the fighting. People who do not or can no longer take part in the hostilities are entitled to respect for their lives and for their physical and mental integrity. Such people must be protected and treated with humanity in all circumstances, without any unfavorable distinction whatsoever. The wounded and the sick must be searched for, collected, and cared for as soon as circumstances permit. Medical personnel and medical facilities, transport, and equipment must be spared. The Red Cross, Red Crescent, or Red Crystal on a white background is the distinctive sign indicating that such persons and objectives must be respected. Any captured combatants and civilians under the authority of an adverse party are entitled to respect for their lives, their dignity, their personal rights, and their political, religious, and other convictions. They must be protected against all acts of violence or reprisal. They are entitled to exchange news with their families and receive aids. Their basic judicial guarantees must be respected in any criminal proceeding against them. These rules are the essence of IHL. The ICRC formulated these rules with the aim of promoting IHL. This version does not have the authority of a legal instrument and does not in any way seek to replace the treaties in force. 2. What are jus ad bellum and jus in bello? Jus ad bellum. Jus ad bellum refers to the conditions under which states may resort to war or to the use of armed force in general. The prohibition against the use of force amongst states and expectations to it, self-defense, and UN authorization for the use of force, set out in the United Nations Chart of 1945, are the core ingredients of jus ad bellum. Jus in bello. Jus in bello regulates the conduct of parties engaged in an armed conflict. The meaning of IHL is equivalent to that of jus in bello, as it seeks to minimize suffering in armed conflicts by protecting and assisting all victims of armed conflict. IHL applies to the belligerent party regardless of the reasons for the conflict or the justness of the causes for which they are fighting. If it were otherwise, implementing the law would be impossible, since every party would claim to be a victim of aggression. IHL is intended to protect victims of armed conflicts regardless of party affiliation. That is why jus in bello must remain independent of jus ad bellum. Three. What are the origins of international humanitarian law, IHL? Since ancient history, there have always been efforts to protect individuals from the worst consequences of conflict and war. However, it was only during the second half of the 19th century that international treaties regulating warfare, including rights and the protection of victims of armed conflicts, emerged. IHL prior to its codification. Modern IHL was not established as a result of the founding of the Red Cross in 1863, nor as a result of the adoption of the original Geneva Convention in 1864. There has never been a war in history that did not have its own rules governing the conduct of hostilities from their outbreak to their cessation. Kinsey Wright said, "Taken as a whole, the war practices of primitive people illustrate various types of international rules of war known at the present time. Rules distinguishing types of enemies, rules determining the circumstances, formalities and authority for beginning and ending war, rules describing limitations of persons, time, place, and methods of its conduct, and even rules outlawing war altogether. The first laws of war were proclaimed in ancient times and are not an invention of our modern era. Hammurabi, king of Babylon, said, 'I establish these laws to prevent the strong from oppressing the weak.' Many ancient texts such as Mahabharata, the Bible, the Quran, all contain rules advocating respect for the adversary. For example, the Fakiate, which was a text written during the period when the Arabs ruled Spain towards the end of the 13th century, contains a code for warfare. Similarly, in medieval Europe, knights were required to follow rules of chivalry, which was a code of honor that ensured respect for the weak and for those who could not defend themselves. All these examples can be considered as reflecting the universality of IHL. Who were the founders of contemporary IHL? There were two men who played a vital role in the emergence of contemporary IHL. These were Henry Donnet, a Swiss businessman, and Guillaume Henry Dufour, a Swiss army officer. In 1859, while traveling in Italy, Donnet witnessed the grim aftermath of the Battle of Solferino. After returning to Geneva, he recounted his experiences in a book entitled A Memory of Solferino, which was published in 1862. General Dufour who also had experience of war, was keen to offer his active moral support for Donet's ideas, notably by chairing the 1964 diplomatic conference at which the original Geneva Convention was adopted. In 1863, together with Gustavo Moynier, Louis Appia, Theodore Manoir, Donet and Dufour founded the Committee of Five. This was an international committee for the relief of wounded military personnel. This committee later developed and became known as the International Committee of the Red Cross in 1876. How did contemporary IHL come into being? In 1864, the Swiss government, at the promoting of the 5 founding members of the ICRC, organized a diplomatic conference. This conference was attended by 16 states, who adopted the Convention for the Amelioration of the Condition of the Wounded in Armies in the Field. This was the birth of modern IHL. When does IHL apply? IHL applies only in situations of armed conflict. It offers 2 systems of protection. A. For international armed conflict. B. For non-international armed conflict. Therefore, the rules which can be applied in a specific situation will depend on the classification of the armed conflict as to whether it is international armed conflict or non-international armed conflict. A. International Armed Conflict, IAC. IACs occur when one or more states resort to the use of armed force against another state. An armed conflict between a state and an international organization is also classified as an IAC. Wars of national liberation in which the people of the nation are fighting against colonial domination, racist or dictatorial regimes, and or foreign occupation with the aims of exercising their rights of self-determination are classified as IACs under certain conditions. Non-international armed conflict, NIAC. Many current armed conflicts today are non-international in nature. An NIAC is an armed conflict in which hostilities are taking place between the armed forces of a state and organized non-state armed groups, or between such groups. For hostilities to be considered an NIAC, they must reach a certain level of intensity, and the groups involved must be sufficiently organized. IHL treaty law has established a distinction between NICs within the meaning of Common Article 3 and NICs falling within the definition provided in Article 1 of Additional Protocol 2. Common Article 3 applies to armed conflicts not of an international character occurring in the territory of one of high contracting parties. These include armed conflicts in which one or more organized non-state armed groups are involved. NIACs may occur between state armed forces and organized non-state armed groups or only between such groups. Additional Protocol 2 applies to armed conflicts which take place in the territory of high contracting party between its armed forces and dissident armed forces or other organized armed groups which under responsible command exercise such control over a part of its territory as to enable them to carry out sustained and concerted military operations and to implement this protocol. The definition of an NIAC in Additional Protocol 2 is narrower than the notion of NIAC under Common Article 3. What are the Geneva Conventions and their additional protocol? The origins of the 1949 Geneva Conventions. It was only in 1949, after the Second World War had ended, the states adopted the 4 Geneva Conventions, which remain the present cornerstone of IHL. While the first 3 Geneva Conventions of 1949 grew out of existing treaties on the same subjects, the 4th Geneva Convention was absolutely new, being the first IHL treaty to deal specifically with the protection of civilians during armed conflict. The death toll among civilians during the Second World War was one of the reasons for the development and adoption of such a treaty. The origins of 1977 Additional Protocols. The 1949 Geneva Conventions were a major advance in the development of IHL. After decolonization, however, there was a need for rules which could be applied to wars of national liberation as well as civil wars, as the occurrence of these increased significantly during the Cold War. Treaty rules on the conduct of hostilities had not evolved since the Hague Regulations of 1907. Revising the Geneva Conventions might have jeopardized some of the advances made in 1949, so a decision was made to adopt new texts in form of protocols additional to the Geneva Conventions, which took place in June 1977. In 2005, a 3rd protocol additional to the Geneva Conventions was adopted. This instrument recognizes an additional emblem, round, which has come to be known as the red crystal. Content of the Geneva Conventions and additional protocols. The Geneva Conventions protect every individual or category of individuals who are not or no longer actively involved in hostilities. First Geneva Convention. Wounded or sick soldiers on land and members of the armed forces medical services. Second Geneva Convention. Wounded, sick, or shipwrecked military personnel at sea and members of the naval forces medical services. Third Geneva Convention. Prisoners of war. Fourth Geneva Conventions. Civilians, such as foreign civilians on the territory of parties to the conflict, including refugees. Civilians in occupied territories. Civilian detainees and internees. Medical religious personnel or civil defense units. Common Article 3 provides minimum protection in non-international armed conflicts. It is regarded as a mini-treaty because it represents a minimum standard from which belligerents should never depart. The rules contained in Common Article 3 are considered to be customary law. Additional Protocol 1 supplements the protection afforded by the 4 Geneva Conventions in international armed conflict. For example, it provides protection for wounded, sick, shipwrecked civilians, and civilian medical personnel. It also contains rules on the obligation to search for missing persons and to provide humanitarian aid for the civilian population. Fundamental guarantees are provided for all persons, regardless for their status. In addition, Additional Protocol 1 codified several rules on protection for the civilian population against the effects of hostilities. Additional Protocol 2 develops and supplements Common Article 3 and applies in non-international armed conflicts between the armed forces of a state and dissident armed forces or other organized armed groups, which, under responsible command, exercise such control over a part of its territory as to enable them to carry out sustained and concerted military operations and to implement this protocol. Additional Protocol 2 strengthens protection beyond the minimum standards contained in Common Article 3 by including prohibitions against direct attacks on civilians, collective punishment, acts of terrorism, rape, forced prostitution, and indecent assault, slavery, and pillage. It also provides rules on the treatment of persons who have been deprived of their liberty. What is the difference between IHL and the human rights law? Human rights law is a set of international rules which have established by treaty or custom, on the basis of which individuals and groups can expect and or claim certain rights that must be respected and protected by their states. The body of international human rights standards also contains numerous non-treaty-based principles and guidelines which are known by the term soft law. While IHL and the human rights law have developed in their separate ways, some human rights treaties include provisions that come from IHL. Two examples of this is the Convention of the Rights of the Child and its optional protocol on the involvement of children in armed conflict and the Convention of Enforced Disappearance. IHL and international human rights law are complementary bodies of international law that share some of the same aims. Both IHL and the human rights law aim to protect the lives, the health, and the dignity of individuals, although this may be achieved in different ways. So, although both IHL and the human rights law are different in their formulation, the actual essence of some of the rules of both is the same. For example, both IHL and the human rights law prohibit torture or cruel treatment, prescribe basic rights for persons subject to criminal process, prohibit discrimination, contain provisions for the protection of women and children, and regulate aspects of the right to food and health. However, it is important to note that there are still important differences between IHL and the human rights law. These differences include their origins, the scope of their application, and the bodies that implement them. Origins. It has already been stated that the origins of IHL can be traced back to ancient times. However, current IHL was codified in the second half of the 19th century under the influence of Henry Donnet, who was the founding father of the International Committee of the Red Cross. Human rights law is a more recent body of law, and it had its origins in certain national human rights declarations, which were influenced by the ideas of the Enlightenment, such as the United States Declaration of Independence in 1776 and the French Declaration of the Rights of Man and of the Citizen in 1789. It was only after the Second World War that human rights law emerged as a branch of international law, which was influenced by the United Nations. The Universal Declaration of Human Rights of 1948 first defined human rights law at an international level in a non-binding General Assembly resolution. It was only in 1966 that this declaration was translated into universal human rights treaties. The International Covenant on Civil and Political Rights and the International Covenant of Economics, Social and Cultural Rights, both of 1966. Temporal scope of application. While IHL applies exclusively in armed conflicts, human rights law applies, at least in principle, at all times, both during times of peace and during armed conflict. However, unlike IHL, some human rights treaties permit governments to derogate from certain obligations during public emergencies that threaten the life of the nation. However, derogation must fulfill certain criteria. It must be necessary and proportional to the crisis. It must not be introduced on a discriminatory basis. It must not obstruct or violate other rules of international law, including provisions of IHL. There are certain human rights which can never be derogated from. These human rights include the right of life, the prohibition against torture or cruel, inhuman or degrading treatment or punishment, the prohibition against slavery and servitude, and the prohibition against retrogative criminal laws. Geographical scope of application. Another major difference between IHL and the human rights law is their extraterritorial reach. That IHL governing international armed conflicts applies extraterritorially is not a subject of controversy, given that its purpose is to regulate the conduct of one or more states involved in an armed conflict or the territory of another. The same reasoning applies in non-international armed conflicts with an extraterritorial element. The parties to such conflicts cannot be absolved of their IHL obligations when the conflict reaches beyond the territory of a single state. Despite the views of a few important dissenters, it is widely accepted that a human rights law applies extraterritorially. Extraterritorially based inter alia on decisions by regional and international courts. To date, there is no precise extent of such application which has been determined. Human rights bodies generally admit to extraterritorial application of a human rights law when a state exercises control over a territory, e.g., occupation, or a person, e.g., detention. Human rights case law is unsettled, however, on the extraterritorial application of human rights norms governing the use of force. Personal scope of application (IHL) aims to protect persons who are not or are no longer taking direct part in hostilities. It protects civilians and combatants or de combat, such as the wounded, the sick, and the shipwrecked or prisoners of war. Human rights law, which was developed primarily for peacetime, applies to all persons within the jurisdiction of a state. Unlike IHL, it does not distinguish between combatants and civilians or provide for categories of protected person. Parties bound by IHL and the human rights law. IHL binds all parties to an armed conflict and establishes an equality of rights and obligations between the state and the non-state side for the benefit of everyone who may be affected by their conduct. This is seen as horizontal relationship. Human rights law explicitly governs the relationship between a state and persons who are on its territory and or subject to its jurisdiction. This is seen as a vertical relationship. It extends the obligations of a state vis-à-vis individuals across a wide spectrum of conduct. So, human rights law binds only states as evidenced by the fact that human rights treaties and other sources of human rights standards do not create legal obligations for non-state armed groups. The reason for this is that most groups of this kind are unable to comply with the full range of obligations under human rights law because, unlike governments, they cannot carry out the functions on which the implementation of human rights norms is premised. Here is a notable exception to this generalization about non-state armed groups. Those cases in which a group, usually by virtue or of stable control of territory, has the ability to act like a state authority and where its human rights responsibilities may therefore be recognized de facto. Substantive scope of application. IHL and the human rights law both share common rules, such as the prohibition of torture, but they also contain very different provisions. IHL deals with many issues that are beyond the pure view of a human rights law, such as the status of combatants and prisoners of war, the protection of the Red Cross and Red Crescent emblems, and the legality of specific kinds of weapon. Similarly, human rights law deals with aspects of life that are not regulated by IHL, such as the freedom of the press, the right to assembly, to vote, to strike, and other matters. In addition, there are areas that are governed by both IHL and the human rights law, but these can be in different and even in contradictory ways. One specific example is the case for the use of force and detention. Regarding the use of force, the rules of IHL regarding the conduct of hostilities recognize that the use of lethal force is inherent to waging war. This is because the ultimate aim of military operations is to prevail over the enemy's armed forces. Parties to an armed conflict are thus permitted, or at least are not legally barred from, attacking each other's military objectives, including enemy personnel. Violence directed against those targets is not prohibited by IHL, regardless of whether it is inflicted by a state or non-state party to an armed conflict. Acts of violence against civilians and civilian objects, as well as indiscriminate attacks, are by contrast unlawful because one of the main purposes of IHL is to spare civilians and civilian objects the effects of hostilities, and under IHL, precautions must be taken in order to minimize civilian losses. Human rights law was conceived to protect persons from abuse by the state. Human rights law does not regulate the conduct of hostilities because parties to a conflict, but it does regulate the manner in which force may be used in law enforcement. Law enforcement asserts itself upon what is known as a capture rather than kill approach. This means that the use of force must be the last resort for protecting life, when other means are ineffective or without a promise of achieving the intended result. It must also be strictly proportionate to the legitimate aim to be achieved, e.g., to prevent a crime, to effect or assist in the lawful arrest of offenders or suspected offenders, and to maintain public order and security. Concerning detention, both IHL and the human rights law provide for rules on the humane treatments of detainees concerning conditions of detention and the right to a fair trial. However, there are differences when it comes to procedural safeguards in internment, i.e., the non-criminal detention of a person based on the seriousness of the threat that his or her activity poses to the security of the detaining authority. Internment is not prohibited during armed conflict, and in general, a judicial review of the lawfulness of the detention is not required under IHL. Outside armed conflict, non-criminal, i.e., administrative detention is highly unusual. In the vast majority of cases, people are deprived of their liberty because they are suspected of having committed a criminal offense. The International Covenant of Civil and Political Rights guarantees the right to liberty of person and provides that every individual who has been detained for whatever reason has the right to judicial review of the lawfulness of his or her detention. This area of a human rights law is based on the assumption that the courts are functioning, that the judicial system is capable of absorbing all persons arrested at any given time, regardless of their numbers, that legal counsel is available, that law enforcement officials have the capacity to perform their tasks, etc. Circumstances are very different during armed conflict, which is reflected in the provisions of IHL. The interplay of IHL and the human rights rules governing the use of force and the procedural safeguards for internment, at least in international armed conflicts, must be resolved by reference to the lex specialis, that is, to provisions of IHL that were specifically designed to deal with those two areas. The end of Module 4. The end of recording.